Okay. Okay, I think I'm live. Okay, so I'm live. There are at least 2 people watching online. There are 3 people here. So we'll get started. So I want to go over the question on page 685 we covered last class. We didn't quite finish. We ran out of time. So we can go back to that. It was the question about who prevails in a certain conveyance given a notice statute and a race notice statute. So go to page 685. It's that problem. Problem 2, I think. Yeah, that's problem 2. Unfortunately, there's only 3 of you here, so you can be called on a lot today. I'm sorry, but I do appreciate the attention that you're joining. All right, so Daniel, let's just talk about the first one, right? It says, I'll read it. It says, O conveys Whiteacre to A, who does not record. O then conveys Whiteacre to B, who purchased in good faith for consideration, but does not record. At that point, Daniel, right? At that point, does B have any basis to know about the prior transaction? At that point, right. The important point is when B makes his transaction, he has no ground whatsoever to know that the other transaction, O to A, occurred. Then A is a crook. Or is he not? I don't think he is. A then goes ahead and sells to C. Right? C purchases it in good faith. B then records. Once B records, C is now on notice that something's up. C records after the fact, right? But here's the key point. When C recorded, at that point the B deed was already recorded. But Daniel and C purchased Whiteacre. Was there any way of C knowing the time of the purchase?
Of B's purchase?
Yes, that's right. The key point is this: even though C could have known at the time of the purchase that there was this other transaction, at the time of the recording that there was other transaction, at the time of the purchase, he couldn't have known. And this is similar to the Lewis case, right, from California. The courts are generally not going to require you to perform a title search at multiple junctures, right? If C went ahead and did his title search at the time he acquired Whiteacre, he would not have been able to know about the prior transaction to B. So it's an important point, right? Even though C recorded after B, when the purchase happened, he didn't know. All right, so Daniel, walk me through, right? Who here prevails in a dispute, B or C? And we're in a notice jurisdiction. Who prevails? Why do you say B?
I forgot there was no notice of the prior transaction. I think we got that far.
Okay, but sorry. Who prevails, A or B? A over B. Who prevails? Okay, so let's do this one at a time, right? Between A and B, you say B has a stronger claim, right? Why do you say B has a stronger claim?
He'd already completed his transaction, and he didn't have any notice of A's.
Yeah, this is easy, right? When B made the transaction, there was no way for B to know about the A transaction. Okay, now Daniel, keep going, right? We're in a notice jurisdiction. Between C and B, who prevails there in a notice jurisdiction?
Between B and C, it'd be C.
Okay.
To know about B's.
Exactly. C took C took Whiteacre. I'm looking around, there's no one there. It's forced to have it. C takes Whiteacre without notice and for consideration. And therefore C is protected because she's a bona fide purchase for value. It doesn't matter that B recorded first. That's the important point. At the time that the transaction was happening and the title search was being performed, there was nothing recorded to put C on notice this other transaction existed. So C is the bona fide purchaser. She had no way of knowing, even though B recorded first. Okay, even though B recorded first. So in a notice jurisdiction, C prevails. Okay?
Quick question.
Yeah.
In line 3, it said A then records and then conveys to C. So is that A recording first, right? Protecting.
A is recording the deed from O to A.
Yeah. There's already O to B.
The O to B deed had not been recorded yet. It's bad grammar. I know what you're thinking.
Okay,
Right?
okay.
No, I had the same reaction when I read it. It's poorly written. What they should have said is A records the deed from O to A.
Gotcha.
I had the exact same reaction. I read that. It's not well written. I'll send a note to the editor later, but it's a poor writing. Okay.
Yeah. So under like a notice statute, going for number 2, be purchased in good faith and for value consideration. So we could say under a notice jurisdiction, B would have a stronger claim than A.
Yes, but C has a stronger claim than B. And the way to think about this is you have to rank your people, right? First comes A, then comes B, then comes C. C has the strongest claim. Or I guess you could reverse it. C has strongest, then B has the middle one, then A is the weakest. However you want to sort it. But always keep in mind who has the strongest claim. It's not who wins, it's whose claim is stronger. Because B will beat A, but C will beat B. That make sense? All right. All right, Anthony. Let's try if it's given a race notice jurisdiction. That's like the rule that California has, for example.
Okay.
So again, who prevails with a race notice, A or B? Right? Who has a stronger claim?
Well, looking at this problem, A then he recorded first before B.
Good.
So in this case, under race jurisdiction, it would be A.
Okay, so A actually prevails over B. Why? Because A recorded first. In a notice jurisdiction, it doesn't matter who records. But in a race notice jurisdiction, it's like the hybrid, A will prevail over B. Okay, now I think, what about C and B?
Okay. What about C and B? I would say
Who prevails there?
B would have a more stronger claim than C because B recorded it before C recorded.
Okay, but here's the catch, right? This one's actually a little tricky. We say that A has the stronger claim, right?
Mm-hmm.
Who did A give it to?
He gave it to C.
Ah. A gave it to C. Once we say that A has a stronger claim, then A's transaction to C was fine. Right? It didn't even matter if C had notice of B's claim. Right? Because in a race notice jurisdiction, A had good title. And A gave his good title to C. So it actually tricks things up, right? A beats B, but C prevails in any event. So C is the ultimate winner in this question, right? C is the strongest claim in the end of the game, but A would beat B. It's a little bit counterintuitive, but once you think of A, in fact, did have the stronger claim, he can then give it to C. Make sense?
And because he gave it to C, C has the strongest
Against B. So C beats B in either jurisdiction. But the only difference is A will beat B in California, whereas in Texas, B will beat A. That will be the distinction. Yeah, and again, don't get too tripped up on which, California versus Texas. I'll give you on the exam if you're in a notice or a race notice. I mean, I think I might, if I say we're in Texas, I might expect you to notice jurisdiction. We cover that, but generally I'll tell you what kind of jurisdiction we're in. So just keep track of that. Okay. Any questions on that? Okay, very good. All right. Again, I'm sorry I don't have my board here, the projector. I can't get they didn't turn it on as I was supposed to. If you go to page 692, please, example number 7. All right, do you want to read that one, please, for me?
Well, certainly, man.
Oh, Andrew, not Anthony, I'm sorry.
Example number 7?
Yeah, on page 692.
All right. O conveys to A who does not record. A conveys to B who records the A to B deed.
Good.
O conveys to C a purchaser for value who has no actual knowledge of the deeds from O to A and from A to B. C records. Who prevails, B or C?
Okay, I'll get there in a second. So first off, O conveys to A, and that transaction is ever recorded. Then we see that A gives to B. Now, A doesn't record the original grant, the OG deed. He only records a subsequent one. He records the A to B deed. Okay? Then O sells it to C. Andrew, if you're just pretend you're C for a minute, right?
Mm-hmm.
What's the only name that you would know to check in the grantee index? Like what name would you think to check there?
Oh.
Exactly right. Do you know anything about A or B?
No.
Okay, so if you're C and you do your title search, you do your reasonable diligence research, you find that O is still the owner, right?
Yep.
Okay, so then who prevails in this dispute, B or C?
And what type of,
I don't think it matters.
oh,
A lot of these questions makes no difference what jurisdiction you're in.
I mean, on a race jurisdiction, it would be B. It would prevail.
Well, just give me notice. I'll make it easier for you. Race is always a little trickier. But in a notice jurisdiction.
If C doesn't have notice of any of those conveyances, then C would prevail.
Yeah, because C is a bona fide. Yeah, exactly. C is a bona fide. I keep looking to the side. It's almost like robotics no one there. C is a bona fide purchase for value. And the key there is C has no way of knowing to look for A or B. The only name that C will know is O. And you can't impose a duty on someone to search for a name that they don't know. All right, make sense? All right. The first case, this Board of Education Minneapolis versus Hughes, is an illustration of this principle, right? That you can't be required to search for a name that you don't know, that you can't figure out. So Dan, you want to just give me the facts generally in the Hughes case, please?
So the plaintiff owned a lot. Oh yeah, so he gives it to they give it to Hughes. Hughes records it, the deed, but he leaves like the grantee name empty,
Very good.
and then inputs his name after that.
Okay.
And it's then the Board of Education conveys it to another person.
Very good.
So they're
Well, no, you got it. You flipped it.
they convey it, and then he puts his name on the grantee. Is that what you're telling me?
Let me jump in. So here's what happened. Here's the sequence of events. In May of 1906, Horger, I think it's Horger owned a vacant lot and sold it to Hughes. Okay, they left the name of the grantee blank. This is similar to a case we did before. Remember where they it was the house in Massachusetts where they left the payee line blank on the check because they didn't know if it was the lady or her son who would be the one to receive the property. So this isn't like an uncommon thing, right? They didn't know who exactly would be the grantee, so they left the line blank. Okay, whatever. That again, there's nothing problematic about it, but the problem is it's only an effective deed between the two of them. It doesn't put the world on notice, but who the correct grantee is. So in 1906, they did this. They executed the deed. They cashed the check. Okay. Then 3 years later, Mrs. Horger apparently was a crook, right? She sold with a quitclaim deed the land to I can't ever say this, Duryea and Wilson. I'll just say Wilson, make my life easier. So she sold a quitclaim deed to Wilson. Now, what do we know about quitclaim deed? There's no guarantees. And I think this is in the chapter. In some jurisdictions, if you're buying a quitclaim deed, that almost makes you a non-bona fide purchaser. The fact that you're taking a quitclaim deed means you're not being careful, right? You're taking a risk on a gamble. So Wilson got a quitclaim deed in 1909. They didn't record that right away. Okay, so again, neither deed was recorded right away. From Horger to Hughes or from Horger to Wilson, neither deed was recorded right away. But then Wilson goes a couple months later, and sells Blackacre to the Board of Education. okay? And they give him a general warranty deed. Now, what's wrong with that, right? If I'm the Board of Education and I'm buying a general warranty deed, I'm going to check where did my seller get it from. And at that point, the seller hadn't recorded yet. In fact, if they've asked, they've only seen a quick claim deed, but there was no recording. Okay, so they sell it to the Board of Education. A couple months later, in early 1910, the Board of Education records the deed from Wilson. Okay, so here's the key point. When the Board of Education recorded the deed from Wilson, there was no way for them to know about the prior transaction from Horger to Hughes, and there's really no way for them to know about the transaction from Horger to Wilson. They just didn't know. And then finally, in December of 1910, Hughes records his deed from years earlier, and then a couple days later, on December 21st of 10, the deed from Horger to Wilson was recorded. So we have a weird situation, right? The deeds were executed in one order, but they were recorded in reverse order. So let me just, if I can give you the chronology, the sequence, straight up. Okay? The first deed that was executed was from Horger to Hughes. The second deed that was executed was from Horger to Wilson. And the third deed that was executed was from Wilson to the Board of Education. Right? So that was in sequential chronological order. But they were recorded exactly mishmashed. Right? The first deed recorded was from Wilson to the Board of Education. The second deed that was recorded was from Horger to Hughes. And then finally, the last deed that was recorded was from Horger to Wilson. So basically, everything was mishmashed and flipped up. So the question then becomes, who wins between Hughes and the Board of Education, right? I'm not so concerned about the first question about when the deed became operative with the signature. That doesn't trouble me too much. I'm more concerned about the second one, right? So Anthony, how does a court approach question number 2, the second question?
How they approach the second question?
Yeah, the first question I'm not so concerned about when they filled in the name. That's not too important for me. But the second one I think is a little bit more relevant to our studies.
Right. They were looking at it saying when the Hughes deed was recorded that there was a record deed to the lot from Durea and Wilson to the plaintiff, but however there was no record showing that Durea and Wilson had any title to convey, and the law they were leaning on like that it was not necessary not only that the deed to the plaintiff be recorded, but that the deed to the plaintiff's grantor should be first recorded.
Okay. So the problem here is one of an incomplete chain of title, right? The chain of title is not complete. And there was a missing link from Horger to Wilson, right? There was no way when Hughes actually finally recorded his deed for him to have known about the Wilson transaction. It wasn't recorded till afterwards. And the court finds that Hughes is a subsequent purchaser for good faith. Wait a minute. How can Hughes be a subsequent purchaser even though he bought it 3 years before Wilson did? And here's where the blank line actually makes a difference. The deed wasn't valid until he put his name on it in 1910. It only became a valid deed when he put his name on the deed. Even though he bought it before, it wasn't a valid deed. So the court says, I think this is a little bit, I don't know, persuaded by this, but the court says this. He actually became a purchaser once he put the name on the deed. And at the time he put his name in the deed, there was no way for him to know about the Wilson transaction. So in fact, even though he bought it first, he was considered a subsequent purchaser for value. And therefore he's protected by the recording statute, and Hughes actually prevails. It's the exact opposite of what you think, right? You think, oh, he was the first one to buy it, but because he left his name blank, which is probably just like a mistake, he's considered a subsequent bona fide purchaser for value who's protected by the recording statute. And again, the key point's this. When Hughes went to go record. There was no way for him to know that the deed from Horger to Wilson ever actually happened. There was no way for him to know about this Board of Education transfer. He just wouldn't know to search for it. So it's an important limitation. So very counterintuitive with these sort of recording questions, because even though he bought it first, the transaction wasn't finalized because he didn't actually pay for it. I mean, he didn't actually put his name on the deed. Yeah, very, very counterintuitive. I don't like this case, but it's there. The questions on Hughes.
So,
Yeah.
just for clarification, it's like if you put your name, if you did put his name on it,
Yeah.
it would go to.
If he had, good. So Anthony, let me ask you the question then. What if he had done it right and he put his name in the transaction, 1906, whatever? What would have happened then? Who would have prevailed?
Well, it would have gone to the subsequent person.
Yeah, the Board of Education, I think. Yeah, right. Because in that case, if he had actually put his name on it, the effective date of the deed would have been 1906, and therefore it would have kicked over a couple of years. So in this case, because of his sloppiness, he didn't put his name on it. It actually saved him a decade down the road, which seems backwards, but that's how the court ruled here. All right, any questions on the Hughes case, the Minneapolis Board of Education case? So I keep looking around. I had an oral argument last month by phone where I was calling into a court. It was an emergency hearing. I couldn't get there in time. And, the court of deputies says, all rise. And I actually stood up in my seat. I'm like, wait a minute, no one's here in my room by myself. So, force of habit. All right, Andrew, you want to go over the facts in Lewis versus Superior Court, please?
All right.
Yeah, it is a confusing case. I'll give you that.
Yeah. So you had, what was his name? An original owner of a piece of property, someone, I can't, the original owner of the property.
Lewis? No, Shipley.
Shipley, yeah.
Yeah, Shipley.
So Shipley was the original owner of a piece of property, and Lewis was contracting to buy the property.
Good.
But before their transaction was finalized in buying the property, Fontana Films
Good.
placed a list.
Okay, do you know what list pendants is?
What I know.
Okay, I'll stop you. I'll come back to you, right?
Oh, okay.
So imagine this, right? You have a litigation against someone, right? You say, I am suing Shipley for whatever it is, $300,000, $1 million, whatever it is. The reason why you do that is you want to put on notice any subsequent buyer that this litigation goes to a judgment and you're taking this property, I can attach your property, right? So the purpose of the list pendants is pending, right? It's to notify them there's pending litigation. So in the event of a foreclosure down the road, they're on notice. So, if I'm Mr. Lewis, I'm going to be hesitant to buy a piece of property with this list pendants attached to it. But the problem was
Within all index.
exactly, yeah. So go on. Just finish the facts, please, Andrew.
So they filed this list pendants, and it got recorded, but it wasn't listed on the index.
Yeah.
Immediately afterwards. So before it got indexed, Lewis, they bought the house, they closed on the house, they checked the title, and there was nothing on the index yet.
Mm-hmm.
So then they closed that title, and then like the next day,
Yeah.
that's when it finally got indexed. And so even before then, Lewis's, they put a substantial amount of money into doing improvements, and they paid off the house the next month. Yeah, the next month.
Mm-hmm.
And that kind of went into some of the issue that Fontana had with the entire transaction, but eventually, the Lewis's brought an action to the trial court seeking to remove the list pendants.
Very good.
From a clear title of the property, and then the trial court denied the motion for summary judgment, and they appealed.
Okay, very good. So, we often speak of the records office, right, where you record stuff. But you forget there are actually human beings working there. And just because you put a piece of paper on their desk and you say record it, doesn't mean they actually record it right away. In fact, they may sit at their desk for a couple days until they actually put it in the book, or if there's a digital system, they put it on the computer system, whatever it happens to be. And this is one of those cases where that gap between when they actually brought it to be recorded and it was indexed made a difference perhaps of millions of dollars at issue. So here's the timeline. In February of 92, Lewis contracts by the House for $2 million. Okay, on February 23rd, Fontana records this list pendant, right? So he records it on the 23rd, but it's not indexed until leap year, right? February 29th. So there's a 6-day gap. There's a 6-day gap where anyone who went to do a title search would not find this list pendants. And usually the title searches are done in about a day or so. Like, at least with my house, they did it in about a day or two. It's not very lengthy process. So let's say they tried doing it on the 24th and the 25th, these things wouldn't turn up. On the 25th, Lewis gives Shipley $350,000 on contract. They close on the 28th. And they got the deed on the 28th. And they gave Shipley a note for about $2 million. Now, what's a note? We talked about this. A note is an obligation to pay money. They didn't go to a bank for whatever reason. They basically made a deal with the Shipley and say, we will pay you about $2 million according to the terms of the note. And apparently they did. They actually made good on their promise about a couple months later. Then finally, on the 29th, right, the leap year, the list pendant is indexed. The key point is this. When they paid the money, when they closed, when they received the deed on the 28th, the list pendants had not yet been indexed. And there was no way at that juncture for the buyer to become aware of this judgment that might be pending. But there's a wrinkle. They paid part in cash, and they paid part with this note, which is basically a promise to pay. Now, without question, when they paid off the note in March of 92, the document was indexed. Right? So the question for you, Daniel, is this. At what point is there an obligation to search the indexes and to find any pending judgments? When you first close? When you first get the deed? When you make monthly payments? At what point does this duty attach to search?
I would say it should be before closing.
Is there an ongoing duty to search every time a mortgage payment, well, not mortgage payment, sorry, every time a payment of the note is being made?
No, because you
Okay. So that's what the court holds, but what was the prior rule in California? It's a little bit, it's a California case. What's going to happen here, right?
If you haven't made all the payments, then you're not the owner yet.
Okay, and what does the Court of Appeals here do with that precedent?
They limit the old case to its facts.
You ever see something like that before? You guys ever see something like this before? Where it's like, well, an appellate court is basically saying we're going to ignore the Supreme Court? This is a very unique case. You don't see this very often. So this is 1994 California Court of Appeals. And they have a precedent from the California Supreme Court from, 1895, so basically 100 years earlier. And as far as we can tell, the California Supreme Court hadn't revisited this. So as a general matter, an intermediary court can't reverse the highest court in the state. You can't do that. So they said, instead, we're going to limit this case to its facts. What the hell does that mean? We're just not going to follow it anymore, right? We're going to say, well, that rule applied to specific facts present in 1895, but we have different facts here, so we're not going to extend it. And they go the exact opposite direction. They say the mere fact that you have payments being outstanding on the note doesn't render you to have this duty to check nonstop about any recently recorded deeds. And they make, I think, what's a fairly practical point, right? Imagine every single time you write a mortgage check, which is basically every 30 days, you have to go do a title search. That's a lot of work and a lot of effort. And really, if you think about it, they should have been more diligent about recording their list pendant. If they had done it more in a diligent fashion, like 5 days earlier, they probably would have been saved. But because they weren't diligent enough, they lost out. Okay? And then they draw a distinction between actual notice and constructive notice. Anthony, what's the difference between actual notice and a constructive notice?
Difference between actual notice and constructive notice.
Yeah, it came a little bit later, but it's referenced in this case.
It say in this case that actual notice is when is it that when the person like fully notices it?
Yeah. When you're personally aware. So, for example, right? Imagine this case, right? That Fontana knocked on Lewis's door and said, "Hey, there's a pending lawsuit against this owner, Shipley, and I have a list pendants against you," right?
Mm-hmm.
That would be actual notice. No, Anthony, what's constructive notice? How does that differ?
Constructive notice would be, say, I want to say where you kind of leave some gray area in it. It's like,
Well, in this case, let's just say in theory, in this case, Anthony, when they made the final payment in March, right?
mm-hmm.
Could they have done a title search to figure out this list pendants existed?
Under constructive notice that they could have.
Exactly, yeah. Constructive notice is notice based on properly recorded instruments, right? That if someone properly recorded this list pendants, you're on what's called record notice, for example, that you can go and search for it. Okay? And that's an important point. The old case from 1895 didn't concern constructive notice. So they say we're going to say that rule doesn't apply for cases with constructive notice. And therefore, when you only have record notice or constructive notice, you have no obligation to do a search in the title office every single time you make a payment on a note or perhaps a mortgage. Okay?
You said it was notice involving instruments?
Yeah. Properly recorded instruments, right? If the deed was properly indexed. Because by March, it was already indexed. There was no question. But it was not indexed in February when the closing happened. So here the court issues a rule I think actually makes sense, right? That even if there's an outstanding payment on a note, you're not obligated to search unless you have some sort of actual notice, something to put you on edge. I mean, imagine a situation, right? The closing was on the 28th, whatever. And then Fontana should say, "Hey, I'd be careful about closing right here because I'm going to record a list pendants any minute now." Or I recorded it yesterday, it hasn't indexed yet. That, I think, would have changed the case. But because there's no actual notice here, the judgment prevails against Fontana. How are we doing? Good? No emails from students yet, so I'm assuming 4 people live streaming this are understanding it.
Yeah.
Oh, God. You want me to check the YouTube comment thread? It's like the cesspool of the world. I once had a student complain about random YouTubers leaving comments on my lectures, and I was like, I don't know what they say. I don't look at those things.
When I've looked at your videos, I've seen a few likes, but no harsh comments. So I think
They're there. I've deleted them. There have been some bad ones. I usually have a filter. I usually get rid of them pretty quick. Whatever. Yeah, I don't see any comments in the thread. Okay. No one's tweeted me as far as I can tell. All right. So we go into the last case, actually. Do you realize how much faster life goes if you have a smaller class?
Yeah. Mm-hmm.
Like, I could teach this class probably in 2 weeks. Like, if I had, a private tutoring, I just maybe in 2 weeks, maybe? Anyway, you can just see what happened when it's done with 30 minutes in. So we have ideas of inquiry notice. And there are 3 kinds of notice, and these are important to distinguish. We discussed 2 of them. The first is called actual notice, and this is where you are personally aware that there's some other interest in your property. This has to be, again, someone coming up and saying, "Hey, Josh, I recorded a list pendants. It hasn't been indexed yet, but FYI, you got to know about this." And if you have actual notice, then it's impossible to claim yourself as a BFP, right? You can't be a bona fide purchaser if you have actual notice of a superior conflicting interest. The second standard is what's called a record notice. And this is the normal run-of-the-mill situation where you do a title search, and based on properly recorded instruments, you can determine that someone has a superior claim. Anthony?
Can we also interchange record notice and constructive?
Record notice is a type of constructive notice. Yeah, let me make that precise. Record notice is a type of constructive notice because it's not actual. If you think about it, actual is the opposite of constructive, right? If you have actual notice, someone told you. If you have constructive notice, there's a duty on you to do some homework and do some research to figure it out. So that's actual notice, that's record notice. And the third category is what's called inquiry notice. And this one's a little bit more tricky. Inquiry notice is a type of constructive notice, but it doesn't depend on properly recorded instruments. It's based on, this is how the book describes, I'll give you the book's definition, facts that would cause reasonable persons to make inquiry. Facts that would cause reasonable persons to make inquiry. So an easy example of this might be a quitclaim deed, right? If someone says, I will not give you a general warranty deed, I'm only going to give you a quitclaim deed, that might put you on notice that something's up and that there might be a broken link in the chain, so to speak, right? So there are cases where you have broken links and they say, oh, I'll only give you a quitclaim deed. There might also be cases where the guy gives you a general warranty deed, but the record has a hole, right? It goes from O to A and then from C to D, but there's a missing link from B to C. You just don't know how it got there in the middle. So if you are buying property and then they give you this sort of broken chain, you might not have the full picture. And if you don't have the full picture, then you can't benefit as a bona fide purchase for value. And there are some jurisdictions, I think the book mentions this, where if you take a quitclaim deed, you're automatically rejected as a BFP, because that should put you on some sort of inquiry notice to inquire further that something might be up. The next case, actually the last case, Harper versus Paradise, I think is an example of inquiry notice, where there are some facts in the record to tell you that you don't have the full picture, right? That there's something missing in the description of the chain that might put you on notice that something's wrong. Okay? All right, Andrew, let's walk through the facts here. I'll help you. The facts here are again a little tricky, but we can walk through this together.
So you have, in 1923, you have Miss Susan Harper, the original owner of a farm.
Yeah.
And she grants to her daughter-in-law,
Maud.
Maud. She gives her a life estate.
And who has the remainder in that one?
Maud's children.
Very good.
And that's and they deed it that way.
Okay.
However, unfortunately, that deed was misplaced.
Yeah.
Until 1957.
Okay, good. Let me just stop you right there, right? So far so good, right? So Susan gives a life estate to Maud, remainder to Maud's children, right? Nothing controversial about this, right? Obviously, Susan didn't really trust Maud to give her fee simple. She only gave Maud a life estate. So as a general matter, if someone conveys to you a life estate, all you can do is convey that life estate to someone else. You can't convey a greater interest, right? Keep that in mind. But then the deed goes missing. And at some point in 1925-27, Susan dies. We don't even know when the woman died. It's actually kind of sad. But she died at some point, and then she's survived by a bunch of people. Then Andrew, what happens in 1928 with the heirs? This is a little bit weird.
So the heirs actually executed a document which acknowledged that there was a deed from Susan to Maud for that life estate and remainder to Maud's children, and that had been misplaced.
Yeah. But what were the heirs trying to do there? Like, what were they trying to do? I mean, it was actually it was a good gesture.
Like a safety net.
But not just a safety net. What were they trying to give Maud?
Like, were they trying to give her?
Think about it. Maud had the life estate, and the kids had the remainder.
Yeah.
What were the kids trying to do?
Guarantee that they'd actually get their property.
No. Oh, it's easier. The kid. What happens when the same person holds a life estate and a remainder?
That'd be simple.
Bingo. So the kids were trying to give their remainder to the mother-in-law. To the mother, and if their mother held both the life estate and the remainder, then she would have fee simple. Everyone understand that point? So they were trying to basically help the mom get fee simple. But the trick here is that their deed referenced this 1927 instrument, right? It didn't supersede that one. It didn't sort of like nullify it. And the three heirs quick claimed it to Maud, and they recorded it as a general warranty deed. Apparently, Maud didn't care much for this property because she mortgaged it for $50, right? Yeah, I mean, she lost it in a couple years later to a loan. She defaulted. The sheriff got it, and then it was owned for a number of years by Thornton. Then it went to Lincoln and Paradise. Lincoln, William Paradise. Okay, and eventually Paradise got it. Maud dies in 1972, but in the meantime, in 1957, this missing deed that was gone actually was discovered in some old trunk somewhere. So Daniel, here's how the case gets a little bit weird, right? What is the relationship between the handwritten deed that was lost years ago and then the subsequent deed that the kids gave to their mother? What's the relationship there?
Well, you said that the second one referenced the last one.
What's the significance of the fact that the second one references the first one?
It didn't, I guess, nullify it.
Yeah. So if you were buying the land from Maud with this handwritten deed, and it makes this reference to this earlier deed, what should that do to you?
Does that give the duty to inquire about
Bingo. Yeah. It puts on inquiry notice, right? The people who got the land from Maud on inquiry notice cannot claim to be a BFP, right? The who's a Thornton and then Paradise, right? They all took the land with this handwritten deed that references this earlier deed, and that's sufficient to put them on inquiry notice that something was up. They call it constructive notice, right? I'll be a little more precise, say it was inquiry notice. And therefore, the inquiry notice prevails, right? And here's the rub. Maud didn't die till 1972. Once Maud died in 1972, it went to her heirs, right? It's as if the 1928 deed never happened. It's a weird idea, but it's as if the 1928 deed never happened, and therefore Maud had till 1972, and then the land goes to her kids.
Because the heirs quitclaimed the subsequent deed.
It wasn't an effective deed because it still referenced the other one. It's about the recording statute, right? So but the key point's this, right? The only way that Paradise can prevail is by benefit of the recording statute. But Paradise cannot win under the recording statute because he wasn't a bona fide purchase for value. He had some notice, some inquiry duty to look further. Therefore, he doesn't prevail. So in the conflict, the kids actually prevail over Paradise. There's a discussion of adverse possession, which I'll mention very briefly. Right? Why the adverse possession claim fail?
Well, the adverse possession failed.
Who are they in theory, who are they squatting against all those years?
The subsequent purchasers were squatting really again.
Who is the owner for all those years till 1972? Maud. So they were squatting against Maud, which is fine. You can do that. What happens when Maud dies?
Then it would subsequently go to her children.
And they didn't squat against the remainderment. Right? That was the important point. They were squatting only against Maud. They were not squatting against the remainderment. And then once she dies, okay, that was nice. They squat against a life estate owner. And in fact, in some places, you can't even I think the book says this. I don't think this is right everywhere, but it says you can't adversely possess against the owner of a life estate. I mean, I guess you can, but it only lasts for that person's life. And once that person dies, it goes back to the remainderment. So actually, the heirs of Harper prevailed here, notwithstanding the notwithstanding this sort of interim instrument. All right.
You can basically say they're not adversely possessing, because it says, like, in this, on 703, is that the appellees assert title by way of peaceful, continuous, open, and notorious. Isn't it supposed to be hostile anyway?
I don't know Georgia law, but they may not require a hostile standard.
Okay.
That's what I suspect.
I just thought like that.
Yeah, it's a good catch. All right. So when you have all these sorts of questions about chain of title, always keep in mind if there's any actual notice or some sort of constructive notice. And it can be record notice in that there's some papers recorded, instruments recorded that might put you on notice. And it can also be inquiry notice that if there's something weird in the document that puts you, spider senses tingling, you should go dig further. Okay. Any questions on that? All right. The last thing I want to talk about, it's fairly brief, is title insurance. It's a very important thing to have, and in most states, the rates are fairly fixed. So, for example, in Texas, if you want to buy a house of $100,000, the title insurance policy is like $800. If you buy a $50,000 house, it's like a $500 policy. So the state actually fixes the rates for title insurance. And the purpose of title insurance is, in the event that there's a defect found later, the title insurance will actually pay for the value of your house. It's a really big deal. So they take it very seriously. And I can tell you that if you want to buy a piece of property and it said that there's some floating around missing deed in a chest somewhere, you would never get a policy written for that land. So one of the benefits of title insurance is to tell you, this is stupid, don't buy this, you're going to lose your money. And that's actually a valuable thing to have. Okay. All right. Yeah, that was quick. Good. Any questions on this topic? No? All right. Well, there's no class on Monday, but I will see you on Wednesday. And have a sweet New Year, everyone. Thank you. Thank you for coming in Saturday.